Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth.
Welcome to today's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney of Florida Women's Law Group. My guest today is Courtney Johnson, attorney at Marks Gray here in Jacksonville, Florida. Courtney has a wide variety of experience in premises liability, trucking and auto liability, general negligence claims, aviation law, but those aren't the reasons we've asked her here today, although it would be interesting. Today, we have Courtney here to talk about surrogacy and assisted reproductive technologies law, which she has begun to practice in, and she is a member of the Jacksonville Bar Association Adoptive and Family Law Section, as well as a member of the Society for Ethics in Egg Donation and Surrogacy. Courtney, that was a mouthful, but thank you so much for being here with us, and we've got a lot to unpack there, which I can't wait for our listeners to find out about all of your experience.
Well, thank you so much for having me. And I'm sure that your listeners are not interested in premises liability or auto. So nevertheless, that is part of my bio. But I'm very excited to talk about all things involving surrogacy and assisted reproduction. And there are certainly some tie-ins as to how those areas of law could affect your work with divorce. So I'm excited to be here.
Well, thank you so much. And, it is because it's family law, right? Divorce falls under family law. And very often, people come to us or they ask me when I meet them, well, Sam, what is family law? I've got a family. Do I need you? Or what is it? And you would think that it is, but there are so many quite specialties within family law and that address your family, like adoption, surrogacy, certainly. And, when we get into like you said, the egg donation and things like that. And then if there is a divorce, oftentimes, there is that intersection and questions, which I think are going to make for a really interesting conversation for us today, because, on this podcast, we're talking to women about women and things. Maybe they've been through a divorce, they want a divorce, or they know somebody who wants a divorce, and which is pretty much everybody, really. Everybody knows somebody who's gotten a divorce.
And at certain points of the day, of course.
I know, right? Yeah, exactly. And anyway, so this affects women and men, but we're women winning divorce. I think this is quite the issue. And when, just so our listeners know, when I met Courtney a few months ago, and she told me about this area of law that she's really trying to grow her practice in based on her experiences, I thought it would be so fascinating to learn, which it has so far. I've already learned so much from you on this topic. And therefore, there's got to be, I know there are other people out there and women who have maybe been on this journey, are thinking about it, or know somebody who is. And I think they'll find this really helpful today. So I appreciate you sharing your knowledge with us today, Courtney.
Yes, thank you.
So today, as we discuss the complexities of surrogacy and assisted reproductive technologies within family law, I think we just got to start at the very beginning. What is surrogacy, and a little bit about how you got to this path, if you don't mind sharing, Courtney.
Sure. And the topic or the phrase assisted reproductive technologies is kind of a mouthful, and I understand that. And generally what that means is there are lots of people, it's 2023. There's lots of different ways that people are growing their family. And it's becoming, as science advances, there's different ways that people are able to grow their family. And in some of those regards, people might need to seek the help of a doctor, whether they need some extra hormonal support, or if they need to go through an intrauterine insemination, that's commonly called IUI. There's lots of acronyms in this kind of area of medicine and law. And then the thing that a lot of people think about, perhaps that's a little more comes to mind when you think about going to a doctor for help to have a child, is IVF, in vitro fertilization, of course. That's been around since about the early 1980s, so 40 plus years now or so. And that's just for everyone's benefit in non-medical terms, it's where a female's eggs will be harvested through, she does a series of hormonal injections for several weeks. Things are checked out. Her eggs are removed and they are fertilized with sperm in a petri dish in a lab at a specialized doctor's office. They're reproductive endocrinologists, the doctors that focus in that area, and embryos are made. And so through that process, and that could be because of lots of reasons, problems with your eggs, problems with sperm, lots of different, maybe you need to screen for a genetic condition. There's lots of different reasons that people undergo IVF. And so then once the embryos are made, those are transferred into the uterus of, most commonly of the mother, but it can also be into the uterus of what's called a gestational surrogate. And so through my own journey with my husband, so my husband and I laughed at the beginning and said, depending on the hour when you want to get divorced, hopefully he won't take offense to that. But we've been together since high school and been married since I was in law school. And we went on a long journey to try and build our family that started with appointments and IVF. And we had several losses along the way and failed transfers and miscarriages. And it was a really challenging time. And so we ended up, to cut to the chase, we ended up, our doctors recommended that we move forward with trying to use a surrogate. So that's what we did. So we have a 3-year-old little boy who is just the joy of our lives. And we worked with a wonderful, amazing surrogate to have him.
And that is an amazing story. And that, I have so many questions. And really first, so I think for our listeners, because, it wasn't that you just, this was not some easy, this was a years long decision before you got to that recommendation, right?
It was several years, yes.
And so now, and I'm in a lot of time and financial investment in the IVF process, and so emotional, I can only imagine with the losses along the way, that now your doctor tells you that, my mind would be just like exploding. Like, where did you even start as far as how to do this, how to find a surrogate?
It certainly was. And I, at the time, did not know anyone else in my world that had, no one from high school, college, law school, Jacksonville. No, I didn't know anyone that had used a surrogate. I didn't know anyone that had been a surrogate. So I really didn't know anything about it. My doctor was wonderful and provided some some resources, some agencies that I could consider. There's adoption agencies. There's also surrogacy agencies that work to match surrogates and intended parents. That's what you're called when you're in my position. And I was also at the time seeing a wonderful mental health counselor who specializes in infertility. She was and is extremely invaluable to me. And I would recommend anyone going through infertility to also seek help in that way. But she recommended several agencies to me that she had worked with or that she was aware of. And so basically I just put my lawyer hat on and started calling and interviewing these agencies and just doing some research in the nights and evenings kind of about the process. And I was basically like a sponge, just trying to gather as much information about what we were possibly getting into as I could.
And that, I appreciate you sharing with us, because it's hard sometimes, I know, to share, personal things, but sometimes those our personal experiences do fuel us into an area where we have a lot of passion because we've had a personal experience with it. Now, when you begin searching, are you stuck to Florida? Because we're both here in Florida. How does that work?
You are not stuck to Florida. So there's agencies all across the country. So we ended up connecting with, and I had the best kind of upfront experience with an agency that was based in California. And they suggested a potential match for us being a surrogate that was in Las Vegas. So we were in Jacksonville. She was in Las Vegas, but she was wonderful on paper and definitely someone that we wanted to meet and move forward with. And it's kind of like a mutual interview process. And so that's kind of how that got started. But no, you're certainly not limited to where you live. There are these agencies, they work with couples all over the world. Surrogacy is still not permitted in some parts of the world, and especially, in some instances for same-sex couples or things like that. So there's people from all over that come into the United States or from within other states, state jumping, they might have an agency here and a clinic here and a surrogate here. So you are not limited to where you are. And we can talk about this as we get going, but the law that applies eventually is you look at where your surrogate lives and where the child is going to be born. That's the law that applies.
Because that's what I was going to ask you, because we've got Florida, California, Nevada, based on your situation and how does that work? So you had to look at Nevada law then. If your surrogate's gonna be in Nevada.
We did, yes, because that's where he was born.
And so how did that work? Because if the agency's in California, did she have to travel to California?
So what we did in our case, some people can have their surrogate travel to where their clinic is, their clinic being their doctor's office.
Mhm.
We ended up moving and using a clinic that was in California. The agency recommended the doctor out there. He worked with surrogates a lot. It's surrogacy in general is a lot more developed in California and Nevada and on the West Coast. It's been a thing there longer than it has been on the East Coast. So there's the practitioners, the doctors, the lawyers, everything. There's a lot to choose from out there. So we ended up doing that also mostly because we liked the doctor, and secondly because it was a 1 hour direct flight for her from Las Vegas to San Diego versus trying to get her to Jacksonville and all that would be required with that. So California at the beginning, and then she went, after the transfer, she would go back to Nevada. And when we eventually had a pregnancy that stuck, it was our third and final one. And she went back and eventually started treating with her own OBGYN that had delivered her own children. And our son was born, I think it was a hospital where her children were born as well.
Now, so let's talk a little bit about the legalities here. So I would imagine you find an agency, and that would be one of the first contracts you sign with the agency. Is that correct?
That is.
And does that cover that? I mean, do they represent the surrogate?
They do not. So it's basically just a matching. They connect the parties together. They work with them on their journey. There's coordinators that will kind of work with you on your journey. I was having already gone through IVF for so many years myself, and we had the benefit of our surrogate had been a surrogate before, so we were both very experienced, knew what we were doing. I'm a little bit take charge. I guess that's the lawyer. So we managed it a lot ourselves, but in some instances, the parties might not speak the same language, or they might be, they might be even further separated than 13 states or however many we were. And so in those instances, the agency kind of acts as a go-between between the parties, but it just really depends kind of how much you need or want them to be involved. But so that's what they do. So that's the first contract
with the agency. Now you also have a legal relationship with the clinic, right? Because you mentioned the clinic, because you ended up moving the embryos to the clinic doctor in California.
Yeah.
Right. So that's another legal relationship, right? Because they're holding your embryos. Is that right?
Yes, if you want to consider it like that. I mean, the surrogate is the patient. We also are, kept informed as far as there's no there's no HIPAA waiver or anything like that we have to do.
right.
We were kept informed as well.
And then you have a contract with your surrogate too.
Yes. So in every surrogacy arrangement, the intended parents, as well as the surrogate and her partner or spouse, if she has one, enter into what's called a gestational surrogacy agreement or a gestational carrier agreement. And that outlines everything from compensation to the intention of the parties being the most important part of the journey, which is that intended parents, Courtney and Matt, intend to be the mother and father of the child born via surrogacy to A and B, who are married but who have no genetic or other relationship with this child, kind of.
Right.
And it's the most important thing too is that for lawyers is each parties have individual representation. So my husband and I had a lawyer. She also had a lawyer, separate.
Which I think would be definitely, you'd have to have it like that because you are both negotiating and
Absolutely.
need it to be where the surrogate has their rights as well. Let me ask you, this just popped in my head. So I apologize for that, but it did when you said compensation, because I knew that the surrogate would be compensated. And I remember I think I thought of this earlier when you and I had spoke, but anyway, I lost it. Because adoption's different on compensation, right? Like, because that has a different connotation. And I mean, that's my belief in whatever I've read or seen. Is that true?
That is true. So the parties that to a surrogacy agree to, if it's going to be a compensated journey, and if that's permitted in your state, it's split out. Generally, it's split out through once there's a heartbeat confirmation at the doctor's office, then there's whatever set amount that the parties have agreed to as far as what the compensation would be is distributed monthly or on a terms of weeks, things like that. So,
but within adoption, and is that, and I'm going to ask something that I certainly wouldn't know if you would ask me, like, because we don't, all the states are different, but generally speaking, is that you really can't compensate somebody other than maybe their medical and basic living and necessities, right, for an adoption? Or
I believe that's correct. I believe that's correct. Yeah,
I think so too. But they're really very different relationships. They're extremely different because essentially you have paid your surrogate and contracted with them to carry your child. And in this case that we're talking about right now, it is your child, but they are the vessel. They are carrying the baby versus generally with adoption, it's their baby, but it's a different contract. It's not yours. So I would think it would have to be very in depth with surrogacy because so much can go right, so much can go wrong, and there's just a lot to it. I guess that's why the agency is so important in doing some vetting beforehand as far as someone who wants to be a surrogate or thinks they do?
Absolutely, yes. So in my experience, and I'm not an agency obviously, but in my experience, the surrogates that are you have to be approved by the agency. There's certain ASRM, American Society for Reproductive Medicine. There's certain guidelines such as you can only have had X number of deliveries. You can't have any serious health complications. Your past pregnancies had to have been relatively stress-free. And they also vet to make sure that they check things like criminal background and credit checks and things like that, because surrogacy is very much premised on that it's a conscious decision by all the parties. It's their intent. They're all adults undergoing through no one is under duress.
Well, there's so much still here I want to talk about, but I think we need to take a quick break. We'll be right back. And during our break, for our listeners, if you'll take a moment and leave us a review on Apple Podcasts or Spotify or whatever medium you're listening to in order to help other women find us here at Women Winning Divorce. And we will be right back. Well, we're back from our break. And again, today I'm joined by Courtney Johnson. Now we've been talking about surrogacy law, a little bit about Courtney's journey, and of course some random questions that I threw in there. But what I want to talk a little bit about now is really some of the legalities, and particularly within Florida, because there are laws, right, Courtney? There are laws that address surrogacy. So we're not that behind the times in Florida. I mean, at least we have some laws, right?
We have a statute in Florida, yes.
Okay, there we go.
Yes.
There we go. And so what does that statute essentially, who is that for? How does that address surrogacy?
Sure. So you can find the Florida surrogacy statute is section 742.15 in the Florida statutes. And it just governs, there's certain things that need to be set forth in your agreement. And it provides for, if you have contracted for a gestational surrogacy agreement at the beginning, and I didn't say this at the beginning, a minute ago, but when you're working with a surrogate to begin with, and you've matched, the next kind of step in the process is that they have to get cleared by your doctor. They do an exam and they look at their medical records. They look at their past pregnancies. They have to get cleared. Then once the doctor says, yep, she's good, that's when the parties move into legal. So that's when attorneys like me get involved representing the intended parents. And then another set of attorneys gets involved representing the surrogate. So that's what I mean that's kind of the context, the phase of things as far as when you get to the agreement. Okay. So our statute in Florida sets forth some requirements, and in order to use the surrogacy statute, the intended parents must be lawfully married, and that's in Florida. And then if you've entered into that, when you go through your surrogacy, it provides for an expedited process to obtain parentage of that baby once they're born. So you go and you get an expedited hearing in front of a family law judge and get an order saying that, intended mother is the mother and intended father is the father. It kind of goes
because in the hospital, they typically come and they do the birth certificate registration. So then in Florida, I guess, does that have to be done again?
Yes.
Okay. Yes. So they're going to still kind of operate as if the surrogate is the biological mother on the birth certificate. And then usually how soon before you get a court order on that being your baby?
So you can usually file the petition within a couple of days after the baby is born, and then the courts provide for an expedited hearing. So it's kind of county specific depending on where you are in Florida, but it's usually pretty expedited, and especially now, and as you know, in our practice of law the last 3.5 years with a lot by Zoom and things like that, it can get done pretty quickly.
Which, right, that is the good thing with that. And I would imagine wherever their agencies and in some of the bigger cities in Florida, like Tampa, Orlando, Miami, at least the judges have seen this before. The courts have seen this, so it's not so foreign. I think if we brought it here in Jacksonville, we need to have it. You're going to have to give an educational seminar first before that starts happening.
I think the public in general, as well as the lawyers and judges and everyone, probably could stand to use some education in this area. It's funny, one of my law partners that I worked with for 10 years and saw me go through all of this, and he said, I have learned a lot about this. So it's certainly but like I said at the beginning, it's 2023 and families are built in a lot of different ways. And I think it's just going to become more and more common. What this week I saw within the past couple of weeks, it's been celebrities that you've seen beyond the Kardashians. There's Chrissy Teigen, Maria Menounos. I might be saying her last name wrong. Erin Andrews. There's several that continue to come at Paris Hilton a little bit ago, a couple months ago. Kim and Khloe Kardashian. So it's becoming, I think it's becoming more a part of the public discussion.
Awareness, because they've become aware, because when celebrities go through things, it's in the news. Unfortunately, Courtney, when you go through stuff, I don't think they put it on the news or ETV.
No, I don't think so. No.
So not as many people get to know and understand that, okay, and there are a lot more reasons, which I think that, I read the article on the reporter, Erin Andrews, and it was very similar, I think, to your journey and, how they got there.
Like she had a
lot of trouble.
A lot of challenges. So.
A lot of challenges. And So then it's not that, celebrities are just doing this so nobody knows they're pregnant, which maybe, I mean, who knows, why, but, and maybe that's like was part of it, but at some point when it started, but I think it's helpful for people to get an understanding and have a recognition that this, is the only way for many people, many women and couples to have children. And, when you are able to go this route, there is a lot. I mean, you've got to really educate yourself and surround yourself with the right professionals to help protect you and your rights as well as the
Absolutely.
surrogate.
Absolutely. Yeah.
Um, yeah, and I mean, I can't imagine it would be appropriate. At least now there are statutes because it does, they've got to have advocates, they've got to have representation, the surrogate as well as the parents. And I would imagine a time, long ago before there were these laws in a lot of states, it happened, but so much could go wrong, right? If you're not protected legally.
That's for sure. There was an example a couple of years ago where Sherry Shepherd, she's on the View, or was, I don't keep up with that, but she and her husband went through a surrogacy journey, and they used a donor egg, so the baby was not going to be related to Sherry in any way. That was the decision she and her husband made in trying to grow their family, and they, in the course of after their surrogate got pregnant, their marriage broke down and they got divorced. And Sherry tried to later go back and say, I'm not this child's mother. Don't put me on the birth certificate. Don't have me pay child support. This was in Pennsylvania because that's where their surrogate lived. And it went through its round of appeals and everything. And the court in Pennsylvania said, nope, we're looking at the intention that you and your husband entered when you entered into this agreement, and it was that you were this child's mother, and therefore you're responsible. So, as far as I know, it's the baby is now 5 or so years old, and she's paying child support.
Mhm. Well, and I think that's also important because you and I had this conversation how the courts here in Florida would treat something like that when a similar situation. Well, I guess a similar situation, but it's not the same because the laws in Florida would be a little bit different, right? If you were the donor, but I think you and I talked about it in the intent of the parties to parent that child and to have that child would control, and it would be an interesting case in the divorce on how to handle that because the courts are going to have to decide the best interest of the child between the husband and wife or the married couple that's getting divorced.
Yeah, it certainly would. And that brings up a lot of things. There's my realm of things about the medical side of things and the legal in terms of what happened when they were entering into gestational surrogacy agreement. But then there's things that you might touch on that I don't, like time sharing and child support and things like that. So it certainly would be interesting if that was brought before, knock on wood, hopefully it won't be, but if that was to come before our courts in Florida.
Absolutely. Now, I do have a question for you because, within the contract because as the intended parents and, contracting with the surrogate, you're already embarking on a huge financial commitment. I mean, is that fair to say?
It's fair to say.
Going down this road.
It's fair to say, but actually, when I think the math on it is like when you do the consideration of how long someone's pregnant, it amounts to like only $5 an hour or something like that. It's but that's fair to say.
But fair to say, it is considerable financial commitment. Now, I have a question for you on the legalities, even though this doesn't have to do with the divorce, but certainly within that contract you cover because this person is embarking to carry your baby, and yes, they're getting compensated, but what if something happens to them as a result or complications of the pregnancy or anything in their health? Like what kind of liability do you as the intended parents have? And let's just say their child survived, but the mother didn't or something like that. I mean, do you guys have to cover that in a contract?
Sure. So you of course need to have a well-versed assisted reproduction technology attorney crafting these agreements, but the agreements often call for a certain dollar amount for loss of reproductive organs if that was to be something that occurred after the journey, or things like that, you're obligated as the intended parents to keep there's an escrow account that you have in place throughout the journey, and you're obligated to keep that open as long as for up to a certain period of time after the child is born, to cover all medical bills and things like that might pop up. You know how those are. And then in terms of liability, would be making sure the contract obviously doesn't waive anyone's rights as far as medical malpractice or things like that. So there's lots of considerations.
Yeah, and I think that is why it's so important on both sides to have that. Now, are there any circumstances, this I know I didn't ask you before either, where the surrogate could, potentially have some liability, where you as the intended parents would have a cause of action against her for anything like that you guys have to deal with in these contracts?
There's certainly provisions that, so the contracts, when you're looking at them, they're anywhere from 40 to 65 pages, and they are dense, to say the least. And so it certainly covers all kinds of, what if scenarios. Now, if you're asking if the child was to be born with a genetic condition or something like that, no, that's not, you can't have a claim for the surrogate again because of that.
Yeah, I would think not. But if they did something risky,
I'm not going to say no. I don't know how the courts would treat that, especially given with different states, and it's not standardized across the country. There's certain states that have statutes for surrogacy. There's certain states that allow for surrogacy through their case law, and then there's a small handful of states in the country where surrogacy is completely illegal. So it just really depends. You have to have someone that knows what they're doing in that state and is licensed in that state.
I would say so, because there's so much at stake and you want it done correctly.
Absolutely. So what's at stake? I mean, the parents want to be that child's parents at the end of the day, and the surrogate does not want to be that child's parent. And I have a wonderful relationship with my surrogate, and I think she would probably consider herself to be like an aunt or a godmother type to my child. But she certainly doesn't want to be parenting him, especially at age 3.
But it certainly does. I mean, and you've had a great experience with your surrogate, and I'm sure a lot of, not practicing in this area, but I would imagine a lot of the laws have come out of maybe things that went wrong in the past, or especially in California and Las Vegas, where they're a little just a bit more ahead of the times out west.
Yes.
To really where they're able to address it and, try to address all these things that can or have gone wrong.
Yes, for sure. For sure.
Now, so for you, even though you lived in Florida, your surrogacy law was all that law was really under Nevada law. Is that correct?
It was.
And so if someone was coming from another state and using a surrogate in Florida, they would then need to abide by they would be controlled by Florida law, not where the parents came from.
They would. So in that case, if you were coming from Texas and your surrogate was in Florida, your surrogate would have a Florida attorney, and you likely would as well.
Now, I want to ask briefly, because you and I know talked about this before the show, on the health insurance, and I would imagine the agency, this would be something that they would certainly have inquired about, right? Maybe, but like your surrogate, obviously you want somebody who has health insurance, right? But they don't have to, or how does that work?
So a lot of health insurance policies exclude surrogacy. So kind of how the process works, and the agencies are somewhat involved, but there's actually 2 or 3 companies that review insurance policies in the context of surrogacy agreements, and they advise as to whether the policy covers surrogacy or not. And then they also provide or advise of some additional policies that you could buy during open enrollment on the private market. So kind of how it works is the first part of the journey, when you're at the IVF doctor, when the surrogate's getting checked out, and she's gets on a medication regimen to prepare her body for the embryo transfer. And then assuming everything goes well and a pregnancy takes place and the baby keeps growing, the first 10 weeks or so of the pregnancy, that's all done at the IVF doctor, and that is not covered by insurance. Even if the surrogate has insurance, that's not covered by her insurance. So that is generally self-pay for the intended parents. And then when the surrogate is released to her, so you graduate from the IVF doctor once you get 8-10 weeks or so pregnant, and you begin treating with your OBGYN of choice. If the surrogate's policy allows for surrogacy, then she could be treated, and that insurance would kick in. The intended parents are responsible for deductibles and anything that might be out of network or out of pocket, generally. And then once that baby is born, the baby is on the intended parents, on its parents now, on their health insurance.
Health insurance. Wow, that is a lot. Again, and we're just only on the very surface of all of that, but still fascinating for sure. It's time for another break. So we're going to take a short break and be right back. And for our listeners, if you're enjoying this show and have listened to other episodes of Women Winning Divorce, we would ask that you leave us a 5-star review so that others can find our podcast. And please subscribe so that you will never miss an episode of Women Winning Divorce. We will be right back. We're back from our last break, and again today I'm joined by Courtney Johnson. We're discussing surrogacy, common legal issues around surrogacy, and finally in this last segment, I've got to bring in an element of divorce in family law. So I want to talk about the different aspects of assisted reproductive technology and surrogacy, but then how it would intersect with divorce. Which I know nobody, particularly wants to think about or go, when they're going through any of this, but it happens. And so we might as well kind of talk about some of the things that would be an issue. Now, Courtney, we talked about the surrogacy agreements in the last segment, and that's really for the process. You can't really have an agreement necessarily. I don't know. I don't think you could do like a premarital agreement about like surrogacy or anything as it relates to the children, because premarital agreements don't deal with the children necessarily as far as how they're raised. But what about the embryos?
So at the beginning, when I was talking about kind of IVF and how there's different layers of what you might go through in terms of treatment to grow your family. So some people go, IVF is kind of like the top thing that's like your extreme case. You're doing IVF and you make embryos. Oftentimes, if you're lucky and you have a good cycle and good result, you'll have more. You might end up with more embryos than children you're eventually going to have, and so those embryos could be frozen and stored. There's other instances just in assisted reproduction in general where people are freezing eggs or freezing sperm. Maybe you are getting up in age but aren't ready for children yet, and you decide it's probably best for me to freeze my eggs. Or maybe you're going, maybe you've been diagnosed with cancer or another medical condition, and you need to freeze your eggs or freeze your sperm. And so that's kind of the context as to why people might even have frozen embryos or frozen genetic material. And I forgot even what you had asked, but so I'll just Heather. So in the context of a divorce, I think it's important, and I keep hammering this, but I think it's important to say more and more people are going to be utilizing assisted reproduction, not only just as science advances, but I think that companies and businesses are beginning to offer those benefits to their employees more. So I think it's just going to become more and more commonplace. And so perhaps when, of course, no one sets out to get divorced, especially not when they're trying to build their family. But like you said, things can happen. And so I think in the context of considering a client that comes to you for divorce, one thing that you might want to include on your checklist as a practitioner is, to find out if that either that individual individually has, and we'll just use women since you represent women, if they had frozen eggs, or if they had frozen embryos together with their partner. And the reason that kind of comes into play is because clinics will require a written agreement between the parties that kind of says, this is what we want to do with our embryos in the event of death, divorce, etc. So,
which that is, that's where it would be, I think, could be potentially highly litigated. And a lot of ethical questions there, because let's start with the embryos, all right, that have, and I would say if it has both the genetic material of both the parties, that's going to be the biggest issue. And whether you have a live child or not, we know they've got them there. There are still a lot, as you know, and I've certainly know, there's a lot more steps. That doesn't just mean you've got a potential baby right there. We wish it was quite so easy. It's not, but it is definitely a potential that you worked really hard and you both, invested in that financially. But it's not a human, but it's not a living thing, right? So it's just very, what'd you say earlier? It's like quasi.
It's like quasi property. So the embryos are really considered, they're given kind of a special status because of the potential that exists for human life. Obviously, like you said, you need a lot more things for an embryo to grow and develop and become a baby, but they certainly have that potential in the right environment.
And they do, and they're the first step that you need for that. And so, so we have, when you divide your property in the state of Florida, it's basically 50-50 if it's marital, and that would be considered marital property. And I don't think a court would give, wife half and the husband half of the embryos. I just don't, I don't see that working. And I'm not equating for all the listeners. I'm making a comparison. But pets, and people love their pets, as do I. But they're not the same as children in a divorce, and they are, despite what how very many people feel about them, they're going to be treated just straight as property. They don't get a quasi property, nothing, even though they're living, but they're property. So that to me is interesting, because there's so many more ethical, moral conversations and beliefs on these embryos, but we have, and I think that would be the hard thing. We're representing the woman. She's like, hey, we did have a baby, but I want more. He didn't want more. Maybe that's why we're getting divorced. But I know they're sitting right there, and I can give, our son a brother or a sister, because I can carry the baby. I can do that on my own. But the husband may not agree and say, well, I don't want more than one child. Like, that's why we're divorcing. And then, but is the court going to order them destroyed? Does the court have that power? I don't think they should, but
so we haven't, it doesn't appear that we've faced that specifically head on in Florida, but the way that other courts have handled that is they will look to, first they're going to look to the agreement that the parties signed. And when they went through IVF and made those embryos, you have to sign agreements before you even do the first injection. And you'll say, we agree that the embryos should be, A is they should be discarded. B is they should be donated to science. C is, and I'm just giving examples. C is they should be donated to another family, etc. So the way courts have treated that is they say, no, you signed this agreement, it's notarized, this is what controls. Sorry, wife, tough luck. Right. And the general kind of idea on that is the courts are not going to force someone to become a parent against their will.
Right.
There was an exception in one state where the parties had gone through IVF, made embryos, and then later the wife had cancer, and she argued that they got a divorce, and she wanted the custody of the embryos. And custody is not the right word in terms of divorce, but she wanted to use the embryos give them a chance at life. And the court ordered that because of this was her only chance to have a genetic child, and therefore she was allowed to use the embryos. Now there would have to be, I assume, in the context of a divorce agreement, that father in that instance, I would think you'd want to maybe transition his role. Instead of a genetic father, you'd want to make it clear that he was maybe just a sperm donor, or make it clear to the extent that you could under the law that he's not responsible for child support. He's not subject to and he doesn't get any benefits or obligations of being a parent to that child. So the courts have kind of treated it a little differently. And I believe it's Arizona, interestingly, the courts award embryos to the spouse who's going to bring them, who wants to use them, who intends to allow the embryos to develop to birth. So it's really just an interesting context. And I think, in this post Dobbs era that we're in now, we could certainly see some changes in that regard as to how courts treat embryos. Yeah, so it could continue to develop.
I think that it will, and it's really important, and especially for our listeners, because we are talking surrogacy, but all these assisted reproductive technologies, and they exist out there, and very many people may have that, and it's a tough decision because I know I've had family gone through it. It's a lot to get your embryos, but then if you want to go, if you're like, let's go through this again, it's a lot. It's like a 50-50 chance of making it, but yet it can be hard to say goodbye to that in that hope. But whether or not you move forward. So, and you too, as the married couple, do own them. I mean, you
do.
ran the clinic, you own them,
Yep.
you own that, you paid for it, you pay a storage fee, and it's just the courts. I think we're going to have that at some point, because I mean the statistics are pretty high with the amount of people who have to use some kind of assisted reproductive technology, right, Courtney?
Yeah, it's currently 1 in 6 people have to use help, suffer with infertility.
So I mean, and that's just huge. So we're bound to see it. We know, hey, at least if they're married, 50% of them are getting divorced at some point, right? So
Yeah,
at least that's what the statistics say.
yeah. So it's certainly an area, I know in the context of divorce, you're primarily concerned with house and IRAs and things like that, but it's certainly, I think, something that will become more and more a part of your practice as people that utilized those, the health science to have their family then get divorced, unfortunately. So,
well, yeah, I think that it's just they're going to have to make the decision, and if they can't work through it, which tends to be, happens a lot in divorce. I mean, a lot of times people are able to work through, but this is, and I'll speak from the perspective of, the wife, the woman thinking, well, I can carry, right? I can shoulder this burden, but then, I do have sympathy for men thinking, well, I don't want more children out there that I don't even know about, or we already have, like, I don't want more, like that just doesn't comport with me. Maybe I want to move on, and then you're sitting there continuing to have our children. So I recognize that, and I'm not like fully for, well, yeah, you go, have your embryos, but I think it's sensitive, and I think that if people can't come to an agreement, we'll see these decisions in the courts as we move on, because that's how then we see the things, in the law, based on people not being able to agree and judges making decisions and interpreting this kind of thing.
I think so. And the clinic agreements would generally prevail, but you and I know you can argue about agreements and what the parties knew about when they entered into them. So I think it'll certainly become more of an issue as time goes on.
Well, I think so. And, and what you intend and what you expected, and things, the marriage, things didn't go as intended. And, a lot of things I think could be argued with the right lawyer and the right set of facts that, could certainly make an impact. But I so appreciate you being on this show today, Courtney.
Thank you for having me.
I find this area of law fascinating and so relevant. I mean, 1 in 6 couples are going through some form of this, and it's going to affect them. And, the more you know, and then at least you can be sensitive to other people who may be going through this, understanding.
Absolutely. And I really pride myself on bringing that empathy and understanding and situational experience, for better or worse, obviously for better, because my son is here, and but being able to share that with my clients and just know that I could be a personal and legal sounding board and offer advice in both areas.
Absolutely. Well, and I just think that's so important. And, we've reached the, I guess lastly, before we go, Courtney, I ask a question usually like within the divorce realm, but, for women who are like on this journey, what advice could you impart to them? Any kind of tips that might just help them, through this, because you successfully made been through this?
Oh my goodness. Well, it's one of those do as I say, not as I do tips, because I think, my husband would say that the 7 years that we were on our journey, I was a shell of myself, and really just, it was very challenging. I would just say, just keep the faith and the hope, and be open to new, to different ways to build your family than what you might have, envisioned as a little girl. And it's still beautiful. We're still bonded as ever with our son, and it doesn't matter how they get there. The right child is your child is your child, and they're the child that's meant for you, is what I really believe.
Well, that is so wonderful. I appreciate that so very much, Courtney, and I know our listeners will as well. And we have reached the end of our show. Thank you so much to our guest this week, Courtney. And you can find her at Marks Gray here in Jacksonville, Florida. And we will have all of her links on the show notes, and some links to some of her blog posts that are specific on this issue that can hopefully help you if anybody is going through this, or you are yourself. And of course, if someone is going through a divorce or thinking about a divorce, please reach out to us at FloridaWomen'sLawGroup.com. And you can also join our Facebook group, Women Winning Divorce. The link will be below in the episode description. And thank you all for listening. If you enjoyed the show, we just ask that you give us a 5-star review. Thank you so much.
Thank you.
Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.